Bonjour à tous, ça nous fait très plaisir d'être avec vous aujourd'hui.
It's within the justice theme and looking at resolution of customary disputes in Solomon Islands. So just a reminder of some background about where Solomon Islands is. It's part of the small island developing states as they've become known, the SIDS. And you'll see from this map that we're talking about an area with north of the Mariana Islands in the northwest, down to Pitcairn in the southeast. Solomon Islands there is represented by a few little blobs, but in fact it's made up of 900 islands, about 350 of which are inhabited, and that's relevant to this research. The other thing which is very relevant to this research is the fact that there are 80 indigenous languages. So these are some of the hurdles when you're talking about dispute resolution in these countries. So this is just a general representation of the pathway of my research, which some of you I've already bored about, but if you haven't heard about it before, this is sort of where I'm going. So I've done some background work, which I'll mention in a moment or two, and I've looked at existing pathways of dispute resolution in the Solomon Islands. And then I will be going on in the next stage of the SHIRK project to look at some more in-depth analysis with a view to suggestions for where Solomon Islands might go. And also I've said conclusion, but of course it's not going to really be a conclusion, because this is the justice system in Solomon Islands is always going to be a work in progress. But I want to think particularly about the effect of pluralism and the consequences and ways of addressing that, because really very little thought has been given to that. I try to bear in mind always that there are some, although it's what you might call a micro project, that there's bigger ideas to bear in mind. And one is that justice is never one size fits all. So it's perhaps a mistaken belief if you start off thinking we'll have one integrated legal system, one integrated form of dispute resolution, because that's not really what it's all about. And it's not all about a statute or a court or a lawyer. What I'm thinking about as my bigger idea is that what we're looking for here is the means to interact with a system that directs the core values of a community down the path that they respect, and the ones that lead them to outcomes that they would most willingly adopt. In stage one of my SHIRK work, I looked at background. I called on work that I'd done before in this area, and I won't go through this sort of hierarchy, but just to say that we've got two systems working in tandem in Solomon Islands. We have the state system, which has set up this hierarchy of laws in which the constitution is the supreme law according to the state. And side by side with that, we have the customary legal system, which is still extremely strong in the Solomon Islands. That little picture in the slide is the High Court, which is in Honiara, the capital. One important thing about the hierarchy of laws, the state hierarchy, is that it does recognise customary law. Obviously, for Indigenous members of the community, they don't need that recognition because customary law is already operating. But within the state system, when the state courts are deciding disputes, customary law is a recognised source of law, and in fact, it is superior in accordance with the Constitution to the principles of common law and equity. So that's an important thing, again, to bear in mind. The other thing about the state system is it does set out in the constitutional rights provisions some provisions about dispute resolution. I've just put one example there from Article 10.8, and it does talk about having a fair and independent forum to have your matter dealt with and to have it dealt with within a reasonable time. And that has been an issue in Solomon Islands for dispute resolution. So, now, this leads me really to the crux of my research so far. Generally speaking, when people talk about the dispute resolution process in Solomon Islands, what they do is they compare the formal to the informal. So they talk about, on one hand, the state courts, and the other hand, they talk about the indigenous forums. But in fact, my research has led me to this very busy slide because it's a very busy picture. Because I think it's a mistake to think down those lines, which has been great to have the opportunity under this project, thank you very much, to look into this in much more detail. What we have on the one hand of a very broad spectrum is the common law state courts. And for, I would say, the majority of the population in Solomon Islands, they don't know what the hierarchy of state courts is, and they couldn't care, because they don't encounter that. But often when you see this in a textbook or as part of the curriculum, it will be, in fact, the dominating factor in the presentation. But really, it's still extremely important for some purposes, but it's not as important as for the majority of the population as other means of dispute resolution. So, right at the other end of the spectrum, we have some traditional forums, and how that traditional forum will be constituted is really dependent on whereabouts in Solomon Islands that forum is taking place. And that's why I mentioned at the outset the fact that we have these 900 islands, 350 inhabited islands, and the difference in languages, which gives some indication of the difference in cultures. The cultures from one end of Solomon Islands to the other, from island to island, and even from village to village, are very different. And so are the forums for dispute resolution within those villages. Even the term chiefs, I mean, that's a Western term that I've used because it's impossible to cover every name of the traditional leaders who will deal with the forum. The chiefs are it's a generic term, which is easy for me to use, but there are different titles, and I found out, just to give you one example of how fraught that problem is about chiefs, somebody in the western province of Solomon Islands was telling me that you have to be so careful with these titles because there's one area of Solomon Islands that has a name for chiefs, but that name for chiefs, if you use it in the western province, means rubbish bin. So you've got to be very careful that you don't use the wrong term. The chiefs, it may be a hierarchical structure. There are certain places where there are village chiefs and paramount chiefs, and the paramount chiefs will often be doing the dispute resolution rather than the village chiefs, who will be looking more at regulation of matters, public hygiene, and those sorts of things. So a very complex picture there. In the middle, we have what are sometimes called customary courts, but I put this in inverted commas because really they're not, they're statutory courts. We have this bandied around all the time. We have the customary courts in Solomon Islands, but really they're established by legislation. They're only customary in the sense that they deal with minor customary offences. In the legislation which establishes them, it says that they will be established in accordance with the custom and tradition in the areas where they are established. But that is the theory. The proviso to that section really holds sway, and the proviso states that the Chief Justice may determine the constitution of the customary courts. And in fact, that's what's happened. They're established by Chief Justice's warrant, and when you look at the warrant for each of the local courts, you see that it's actually specified. There will be so many justices, there will be so many presidents and vice presidents, there will be a clerk to the local courts. And moreover, the local courts have also been subjected to regulations, and when you look at those regulations, you have to fill in a form to start your proceedings, which is just like a form, simplified form of magistrates' court procedure. So, local courts, they are constituted by justices who come from the community, that's true, but those justices will not necessarily be the traditional leaders. They may be what is termed in Solomon Islands big men in the community. And I use the men advisedly because nearly all the justices in the local court, not all, but nearly all are male. So those are three pillars, if you like, of dispute resolution. But again, that's not the end of the story. There are other, what I've called hybrid forums, because in 1985, a change was made to the local court legislation, and local courts had exclusive jurisdiction for first instant determination of customary land disputes. And one other thing I should have mentioned in my background was that about 87% of the land in Solomon Islands is still under customary tenure. And the Constitution of Solomon Islands says that land in Solomon Island belongs to the people of Solomon Islands and the government, and that's interpreted to mean the government holding it on their behalf. So this is an extremely important jurisdiction. And in 1985, this hybrid system was introduced because it was realised that the local courts are very formal, and therefore that some changes should be made. And now, if you want to take your land dispute to the local courts, you have to show that you have been first to the chiefs. And only if a decision has been made which is unacceptable to one of the parties, then you can go to the local courts. Now that sort of sounds all well and good, but in fact it's not been successful, as almost 100% of cases that go first to the chiefs are taken to the local court, because the person who doesn't succeed, if you like, in the before the chiefs is going on to take a case to the local court. Another hybrid is the Molly Ward Chiefs Council Ordinance. It's a provincial ordinance which establishes a Council of Chiefs which has power to decide all disputes within the Molly Ward, which is a Western government division of the country. And I haven't got time to talk about it now because see if Sophie's reminded me I've only got 5 minutes, but it's just a fascinating piece of provincial ordinance, and it states, as I say, that the Chiefs Council can deal with all disputes, but it also has this provision that says if it's a dispute which is dealt with by a statute as well, the Council of Chiefs will discuss the matter with the police to see whether they should go ahead with it or they should refer it to some other dispute resolution body, which is a very interesting provision. And the other avenue of dispute resolution is the church. Very, very important, because the church in some areas is the de facto government, and in particular in family matters, they deal with a vast amount of disputes. So that's some of the results, if you like, of my research to date. And here I am not being modest about my publications, as Professor Otis has told me not to be, and I thought actually afterwards that there has also been, I've been facilitating a pro bono project in Solomon Islands where I've had some fantastic volunteer undergraduate students who have been doing some great work, which I might add to this because we've actually got a published booklet for the Public Solicitor's Office, which is like the Legal Aid Office in Solomon Islands. And we've done for them a booklet which is mostly in diagram form about the processes for logging, for mining, environmental impact statements. So I'm really proud of that work by our undergraduate students, but it has actually some implications because we've talked about the dispute resolution avenues during those processes. So those are some of the things that have gone. Further research questions, there are so many that have come up within this. I tried to sort of list there some of the bigger questions which have occurred to me, but there are many more. Are there useful lessons from neighbouring small island developing states? There has been a really interesting development in Vanuatu in 2013. They had a new piece of legislation saying that land disputes would be dealt with in the Nakamal, which is the traditional forum. I don't want to get sidetracked with what traditional means and whether it's really traditional, but that is a really interesting piece of legislation. Unfortunately, since that legislation was introduced, there's been a change of minister, and developments to start that ball rolling to actually have the disputes resolved in the Nakamal has come to a standstill, and the new minister has made it quite clear that he is considering repealing the Custom Land Management Act. So maybe a lesson there, but always has to be, as everybody in this group knows, you always have to be so careful in using models from other countries. So, haven't really got a chance to talk about this, because in my further research I want to look more about the advantages and the challenges of having these plural methods of dispute resolution. Okay, I can't really talk about this one. You can see my little white face poking out here at a meeting of customary chiefs in the West, where we talked about some of the issues. It was a very helpful meeting. But Solomon Islands really has very different views as to where it should be going for the future. So these Land and Titles Amendment Bill 2005 hasn't gone any further, but it talked about giving the traditional leaders more power. But alongside this, there were other proposals for going down a different path, which to my mind is really a local courts type thing under a different name. So very different views about where we should be going. Future publications and communications, shan't go too much down that, but got some things in mind, some things in the wind. I've roped Professor Otis in for this panel session in Mumbai, what used to be Bombay, in December, so we'll be talking about multiple legal orders there. And I just 2 days ago been notified that my panel proposal for the Australian Association of Pacific Studies on Pacific legal systems past, present and future has been accepted. So if anybody is likely to be in Cairns in April, please put forward a paper for the panel. Final thought about this disputes resolution. I think, just going back to my comments at the beginning, you know, this so often when this is discussed, it's formality, informality, but in fact, really, I think we might be talking more about choice of appropriateness. And this quote is from Stevens, in fact, in the context of African research, but I think it's a particularly good one. But even then, I think there's more to say here. So maybe we can add to that quote as we go down into stage 2. And this is a contrasting picture to the picture I opened with, taken in the 1980s. There is me, looking much younger, outside the Public Solicitor's Office, where we were looking at a lot of this dispute resolution. There's a constitutional right to assistance from the Public Solicitor's Office, and there are some of us who were leading dispute resolution down the various paths. So, as we say in Solomon Islands, thank you to mas, hem no more, which is thank you very much, that's it.